Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast. I am Michelle Itkowitz. This is going to be my first episode with guests, and I am so honored to have two of the heaviest hitters in the landlord-tenant litigation space in New York City with me today. Randi Gilbert is a partner at Horing, Wellickson, Rosen, and DeGrulier, and she represents landlords. Seth Miller is a partner at Collins, Dobkin, and Miller, and he represents tenants. I am not going to read Randi's or Seth's biography because it would take the whole podcast, but I'm putting links in the show notes to their law firm profiles. I will introduce them in my own way. First, how do I know these two people? I know them as adversaries. Sometimes I am Randi's adversary because I am representing a tenant, and sometimes I am Seth's adversary because I am representing a landlord. So I can tell you that these are two of the smartest people and landlord-tenant work in New York City today. And I have always been impressed with Randi's and Seth's devotion to holding up the highest ethical standards in our profession. But forget my opinion. The fact is, if you take all the major appellate cases that have shaped our landlord-tenant jurisprudence over the last 30 years, either one or both Randi Gilbert and or Seth Miller are involved in many of those cases. These are the people who literally shape the law. Good cause eviction is the biggest change that I've seen in the 30 years that I've been doing this. It's a complete game changer. In episode 25, I explained how good cause eviction works and how it protects tenants. In episode 26, I explained who good cause eviction protects and how you can figure out whether it protects you. In episode 27, I covered good cause eviction's new sweeping notice requirements. Now, in episode 29, I'm giving you a unique chance to be a fly on the wall to listen to an in-depth shop talk among the lawyers who will be litigating over good cause eviction for literally the rest of their careers. One more thing, this show has not been at all political. I always say to you listeners, you can find the banal politics of landlord-tenant drama just about anywhere. You don't need me for that. But there was really no way to offer you this authentic content today without having a little bit of politics sneak on in, because these lawyers are warriors for their clients. Let's just say they have strong opinions. Also, it gets a little wonky and you might not understand every reference to every section of the statute, but that doesn't matter. You will get the gist. And the bottom line remains that you will not hear conversations like this anywhere else. As I always say, the law belongs to you, New York, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. Now let's talk to Randi Gilbert and Seth Miller. So thank you, Seth and Randi, for being here today. Because it's such a big topic, maybe we could just spend 2 seconds. Can one of you spend a few minutes saying what the law does to protect tenants, because it's very different than rent stabilization. And then the other spend a couple minutes explaining who it protects, because it doesn't protect everybody, it only protects some people.
Yeah, well, actually, it's easy to put together. It protects free market tenants who are not in rent stabilized, affordable housing, don't have a small landlord.
What's a small landlord?
Building, 10 or less units, but the tenant will know because the landlord has to notify them. There's a whole packet
yes, and Randi, every landlord will notify every tenant of their rights. She said sarcastically.
The problem is, I don't even think it's sarcastic. My clients are all notifying their as of August 18th, all landlords are required in all renewal leases and all vacancy leases to put in this notice. And in the notice, it will tell them if they're subject to good cause or not. It's in the back of the statute. Rebany actually put out one, and you check the boxes. It's very simple. So if you're not subject to good cause, it's only in New York City and Albany right now. So if anybody's listening to this podcast outside of New York City or Albany, they're not subject to it in a free market apartment until their municipality opts in.
One of the big exceptions is if it's new construction. There's a there's a an exception for certificate of occupancy after January 1, 2009.
Or an interim certificate of occupancy, 2009.
Right, right. Which the core of that, it's clearly meant to protect, to exempt landlords who've created new housing, new being 2009 and after. But it's phrased in a funny way, right? Because you get a C of O just for changing what door you exit from in the event of a fire, right? There's all these different ways to get a certificate of occupancy, and not all of them have anything to do with the creation of new housing.
But the statute doesn't limit it to new housing. It's a CO or an
Okay,
interim
so
CO
that's
2009 forward. So if you get one for whatever reason, and it's 2009 forward, you're not just subject to good
all
cause.
right. So that wasn't even one of my specialty questions, but it should have been. And so let me just jump in and raise it. The way, if I just read the statute the way the statute is, it looks to me like if you get any certificate of occupancy after 2009, you're out of this.
Yes.
But what if you're, a lot of times people, okay, so in rent stabilization, getting a new CO doesn't mean you've made a new building. A new CO is not a new building. It would have to be a CO pursuant to a permit for an NB, a new building. So you're not really adding housing sometimes. Sometimes you're just getting a C of O. Or what if you have one of these old buildings that didn't have a C of O, but your bank wants one, so you go out and get one? You really haven't added or changed anything. So my question is it that just getting the C of O?
The way the statute is written, and Seth just touched upon it, it's not for new construction. He's putting something in there that's not in the statute. So it doesn't say that. It just says a new CO. So if you're going to go straight by statutory construction, any CO, interim or otherwise, 2009 forward, the building is exempt from good cause.
Right,
Well, it doesn't say
and so
interim.
any tenant who wants to invoke this statute is going to have in a building that has any sort of new certificate of occupancy is going to have to overcome the argument that Randi just articulated very well, which is a plain meaning argument arising from the plain language of the statute. There are old cases. If you have a full set of law books, you'll have something called statutes, and that little tiny sliver of a book has all of the rules for statutory construction and all of the ancient cases that stand for those rules. And one of them is the rare exception to the plain meaning rule. And plain meaning is the rule. And you'd be arguing if you're a tenant in a building with a new certificate of occupancy, you'd have to argue for a very narrow exception where there's a real contrast between what the words say and what the purpose of the statute is. There's a presumption against ineffectuality. I don't think the legislature meant to create a loophole so big you could drive a truck through it. Um, but at the core, if the landlord created any new housing at all in connection with that C of O, you're dead in the water. But I do think that there is some room to try to get an appellate court, at least at this early stage, to say, hey, wait a minute. If you didn't create any new housing, if you just divided a restaurant in half and created two new exits, no, that's not that doesn't trump good cause.
I disagree with you. I think they can't write into something that's not in the statute. I could read the statute into you, it's very plain. It's a few words. It all says is 2009 So it doesn't. You're reading in that they meant it to be this. Well, if as you know, if they meant it to be it, they could have easily said it. When you don't say it, you have to take the words as is. So there's no reason to do that, and there's no statutory precedent to say for this to say that in this section.
Well, that's actually an interesting aspect of this. The protection really kicks in as a defense to an eviction proceeding, which is a little weaker than those of us on the tenant side would have liked, right? You don't have a statute that affirmatively obligates the landlord to tender a lease in conformity with good cause.
Well, there's no
Um,
lease conformity with good cause. There's a presumption of a formula, and the landlord can overcome that if they have the requisite amount that they have to spend on a building. So if they have to spend X amount on their expenses, on their insurance, on their taxes, on upgrading the building based upon statute, then they're entitled to a higher percentage.
Correct, correct. And so the way that plays out, at least on the tenant's point of view, is you may get a lease and not be able to run to court and get affirmative relief if the courts ultimately read the statute as Randy has suggested, in accordance with its plain meaning, because the statute is a defense to an eviction proceeding. Uh,
Do you see
in
it as a
the
defense? Seth, I have a question for you. Do you
Yeah,
see it as a defense to a holdover as well as a non-pay? Because the statute reads it's a holdover, but I was
yes.
curious on how you saw it a non-pay.
Well, how would it play out in a non-pay? You're talking about what, a month-to-month tenant who gets a demand for a higher rent. I mean, otherwise there would be a lease.
Right. Well, that's what I'm saying. So it's not a defense to a non-pay. It would just be a non-payment with somebody with a lease. It wouldn't be a defense to a non-payment proceeding. It's only a defense in a holdover
If
proceeding.
you signed the lease, but
Right.
there's
Right.
a
If you
lot
sign
of
the lease.
convoluted law right now, particularly coming from the second department, about whether a non-payment lies against a month-to-month tenant, and when it does and when it doesn't.
Right.
Right?
Mm-hmm.
Because you can not have a lease and yet have gotten some kind of a notice from a landlord saying, "Hey, it's been a long time. You've been paying the same rent for 10 years. Your new rent is now increased by 20%."
Right.
Right? And I would argue that holdover or non-payment, that would good cause would come into play as a defense, but you might not get to that defense because without a lease, without an agreement to pay the higher amount, there is no non-payment.
Right. So if there's a lease, well, then there would be no holdover because there would be a lease. But most loan owners would commence the holdover as opposed to the non-pay because they don't want to get into that whole issue of whether they were entitled to rent because there was no lease.
So let me pose a question to you guys. Very often, if you're representing tenants, you get the question, what's going to do? I sign away my rights if I sign this? So let's say a landlord who, by every other measure, counts as a landlord who's subject to good cause. It's a landlord who owns more than 10 units. The building has not had a new C of O since the 20s or 30s. Sends out a lease with a 15% rent increase, and the tenant signs that lease. Have they signed away their rights under the good cause statute?
Well, they had the right to object, and they didn't have the right to object, so it could be seen as a waiver.
Right, and it's hard to set up the scenario that's in the statute, which is, no holdover lies for refusal to sign the lease. There's no refusal to sign the lease. What do you
Right.
think, Michelle?
Well, I'm going to answer your question with a question because I think with rent stabilization, we have so much law. It's almost like rent stabilization, you could theoretically spend all your time on it. I mean, it's so voluminous. And then you have not only have the first department and the second department, but you have the overlay with the agency and all its case law. It's such a big volume of law. So my question to you is, with good cause, we're standing here today and we have no law. We have nothing. So my question is, how much are the courts going to look to rent stabilization to answer these questions on good cause, and is that going to work?
See, in my opinion, it's problematic if they look to rent stabilization, because rent stabilization is by statute. So most of the
Well,
issues
so
come
is
up.
this.
Yeah, but it's a different statute, and they don't track each other.
They don't, and
So
they're different approaches.
and they're
They're
different
completely
approaches. So
different
how are you going
approaches.
to apply rent stabilization law to good cause when the statutes don't track each other and the courts are interpreting the statute?
Well, the only reason I would say that you might is because we've got 50 years of thinking about what, for instance, is non primary residence or what is owner's use, or even with this new building thing you guys just got on. I think that's, I hate to say it, Randy, I probably would make that argument that Seth is saying because why did they put 2009? It's not a magic number. It was in there
You
because
know
they were
what?
trying to say, did you create new housing? Not did you just happen to get a C of O because your bank told you to? Or actually, Seth came up with an even better example when he said, oh, so you put a new entrance on a restaurant, so you got a new C of O for your building. Does that mean that building is exempt and then another one isn't? Like, what would be the sense
You
in
know
that?
what? I'm sure you would make that argument, and I will be very confident to stand there and point to all of the statutory construction showing how you can't read into law what words that are not there. And what 2009? Well, they could have made, if they're looking for new construction, they could have made it 2012 or 2020, or whatever year they
Or
wanted to
they
do
could
with
have
new
said the words
construction.
new construction. They could have said
No,
Well,
new
they could have
construction.
said new construction. That would have been very easy.
they,
2009 for new
right.
construction.
I agree with you. To make it really clear, they could have just put in a comma and a clause mentioning housing, right?
Right, right. New housing.
If they said 2000, any C of O from 2009 with new units that didn't, residential units that didn't exist before, comma, it'd be clear, right?
Yeah, but I'll read it to you. It says housing accommodation with a temporary or permanent certificate of occupancy was issued on or after the 1st of January 2009 and for a period of time of 30 years following issuance of such certificate.
No
So
question.
nowhere, so this is extremely clear. If they
Well, no,
wanted
it's
to,
not. No,
Yeah,
it's not.
but
if
again,
you wanted
Randy,
to make it new housing, then put the comma in, as he just said. There's nothing in here to support what you're saying.
Well, hold on
You
a second. Here's where it's not clear.
go ahead.
Housing accommodation has a very specific meaning in rent stabilization. It means a unit.
That's okay for with a
Hold on a second.
temporary security.
Let me finish.
Yeah.
Housing accommodation in this statute means building, because if you look at the other exemptions, you can see it only makes sense if it means building.
Well,
So
they use
there's
housing.
no,
Yeah,
but
go ahead.
there's no definition, and there's still at least some argument that using the phrase housing accommodation instead of building means that they didn't mean building.
The house, yeah, the whole thing says housing accommodation. You got housing accommodation,
Right, right. But if you
manufacturing.
but
And you
they're
know what?
using
When they
it as
wanted to,
building.
and when they wanted to make it anything other than a building, they put in manufactured home located or in a manufactured home park. Okay,
right,
or and when they wanted to talk about hotels and transient, they put in the words hotels and transient. That's a number 12. That's not applicable there either. So if they wanted to put new construction in, it was very simple. There's all different. If you keep going down the statute, you'll see different.
yeah,
They had
you'll see one of
exclusive.
those exceptions that exempts units within a housing accommodation,
You'll
which
see
means
right.
that it means building, right? It
But
doesn't
yeah,
mean
but they have. If you look, they have the assisted living. So when if they wanted to put new works in construction, they would have. We got assisted living. We got non for profits. We have all kinds of retirement community.
Randy, I'm not. Nobody's arguing with you the
No,
exact
I know. I'm
language,
just
but
pointing out what's going to happen to tenant people in court when they make your argument. In this,
I'm just pointing out that it is a bizarre and arbitrary date if it wasn't intended to mean C of O pursuant to a new building permit
but
that
why could it?
created
Well,
new
but what
housing.
would be? Well, why is 2009 bizarre? What could have been 2012? Could have been 2006. I don't.
Actually, any date would be bizarre
Right. That's what
because
I'm saying.
it's
It's
just.
Yeah,
But a lot of times,
it's
people in
from a public
Albany,
policy standpoint, it would be bizarre if it didn't mean some type of new housing.
right?
I would
That's all
even
I'm saying.
grant not. I mean, don't hold me to this if I'm in a case, but
That's
I would
okay.
even, I would even grant that if you have a 6 unit building and the new C of O made it into a 10 unit building by reducing the size of some of the apartments, you're probably within the intent of the statute. But just moving around the commercial spaces in some way or other, or creating a garage for somebody who wants to put parking in their building. No, it's not without a fight, not without an appellate decision saying so.
Will be years with this statute.
Well, okay, that brings me to another thing, another question I had, but it's an offshoot of something one of you said. In rent stabilization, the statute specifically gives us the Division of Housing and Community Renewal that has a quasi judicial arm that will deal with certain enumerated disputes between landlords and tenants. Either landlords or tenants can go to the agency, stay out of court, stay out of the public record of court, stay out of the cost and expense of court, and get certain things adjudicated. This statute doesn't come with any of that. So, what struck me was if you're a tenant, and let's say you don't get that notice or that you thought you were supposed to get, or let's say you get the notice and you don't agree with the box that was checked, or you have any grievance under this. It seems to me, and this seems a little problematic, that the tenant's only recourse is to not pay rent and get sued. What else can they do?
Right, or not sign a lease and get sued. And it's the lawsuit by the landlord that triggers the applicability of the statute, as we were talking about before. Unless some tenant lawyer, maybe me, maybe somebody else, successfully brings a declaratory judgment action and the courts say, yes, you can do it that way, the safe thing to say is that it's a defense.
I know,
to
but
hold
here's
over.
the problem. A client comes to either you or I, Seth, a tenant client, and we say, okay, you can get sued or you can go to Supreme Court. And going to Supreme on a declaratory judgment action, that's way more expensive than being in housing court because there's discovery and it's just a lot more complex, and they're also in for a much longer haul. You could be there for 4 years on a declaratory judgment action on the right thing. So
Mhm.
it just almost seems like without the DHCR avenue, there's how are they supposed to enforce their rights other than getting sued?
Yeah, and it's very difficult because once you get out of New York City, where there's a program to provide legal services at least to some people, there's a scarcity of lawyers. That brings me to another question. If so, Albany opted in. New York
Right.
City is already in. Let's say Buffalo was to opt in a year, and let's say they made their ordinance retroactive to when the statute was effective. Can they do that?
Why would they? Why would they? Oh, you're saying that? I don't know. It doesn't say. That's an interesting question.
Yeah.
Retroactivity is obviously, as you know, frowned upon, and there's
Uh,
nothing in the statute that.
That's an inside joke.
And there's nothing in the statute that allows it to be retroactive, and it's supposed to be specifically stated if the legislature wanted it to be retroactive. So I don't see how they could be
well, it's
going
an it's
forward.
an enabling act, right? And so the statute itself enabling the municipal governments is prospective, right?
Right,
This is not a statute that works retroactively on lease offers that were already out there. Well, actually, it
right.
does. But it doesn't work on holdovers that were already commenced. May work. It may, and legal services, I
Well,
believe,
how do you think it worked on leases that were already out there? If you already got a lease and signed it, you think that it would go backwards?
maybe if it wasn't returned, definitely not. If the lease was actually returned, executed, signed, sealed, and delivered, if it's final, I think the anti-waiver provisions of stabilization and rent control are out the window in this statute. I think it's going to be hard for a tenant to assert the same kind of non-waiver
Hmm.
issues that you can easily assert in stabilization. You sign a stabilized lease that is a blatant overcharge, you can get that annulled. It's going to be thrown out the window. If you sign a lease under good cause that's for a
Why?
higher rent than what the landlord was allowed to charge, good luck with that. I don't think the
Why though?
statute
Why
helps
are
you.
you saying that?
Well, because there's nothing in the statute that permits it. He's right. Him and I actually, I went over that with people. There's nothing in here that helps that. If you once you sign it, I agree with him. You have a big problem.
What the statute says is that it's a defense to a holdover for failing to sign a lease,
Right.
right? So how do you get into court let's say you have a pretty persuasive case. You signed a lease at above the percentage, but the landlord didn't give you the notice. Was promised a whole bunch of things that they didn't deliver. Committed all kinds of different fraud. Maybe even promised that they were going to give you a break on the rent under the table, right?
Hmm.
What does the statute allow you to do? There's
No, but
no
in
affirmative lawsuit.
But in rent stabilization, there's nothing in that statute either that gets us to the appellate case law that says that rent stabilization is not. This is how I explain it to my landlord clients and my tenant clients. Rent stabilization is not between a landlord and a tenant. It's between the landlord and the government. It's a regulatory system. And that's why you can
Yeah.
look back a million years to see if
Right.
you're in compliance. There's no statute of limitations. This good cause is also a regulatory system. So how could you
Yeah.
waive its protections?
Well, because you're not really waiving its protections. In rent stabilization, you're supposed to be charging what the correct legal regulated rent is. And each year there's a mechanism on how to calculate the correct legal regulated rent. And you can't, it's not that, like, I was it 2.5 and 3.5 this year. So I can't charge you. I can't charge you 4 for 1 year because my expenses show that I'm entitled to 4 because I can't pay my bills on 2.5. Whereas in good cause, I'm in. It's a presumption, but it's a rebuttable presumption that I may need a higher percentage. So in rent stabilization, if I go above those guideline increases, then my lease is problematic.
Okay. No, but
Because the
to
tenant can
get
get.
to that point in that notice form you were talking about, there's a section, correct me if I'm wrong, because you're the notice lady. The There's a section where you're supposed to be justifying why you're above.
All you have to say
Yeah.
is expenses. It's exactly it. You circle this part that says I'm above the presumptive number. Now it's 8.82%, and you just write the word expenses. I don't have to give you a whole long book on what it is. I can say my expenses, and then from there it'll be what it's going to be.
And you
So,
don't think a court is going to ask to see them and use the
oh, they might.
standards?
Yeah, a court is, if it gets challenged in court, I would have to produce it. But but Seth is right. It's a defense. If I bring a holdover against you because you didn't sign my lease and my percentages were higher, then I'll have to show you why my calculation was correct.
Okay, I'm just jumping in for a minute here to do the housekeeping. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it is legal advertising, it is terrible because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you'd like to hear more about. If you like our work, please give us the 5 stars and put this podcast on your socials. All right, now here's the thing. I think this is a big one. So for years there was this cat and mouse game in rent stabilization where vacancy had value. If the landlord got the tenant out, the landlord could get a 20% vacancy increase, could get individual apartment improvement increases, maybe a longevity increase. So a tenant leaving in rent stabilization up until June 14th of 2019 in the Housing Stability and Tenant Protection Act meant more rent for the landlord. So there was a push always to get rent stabilized under market tenants out. They ended that with the HSTPA in June of 2019 by taking away the value that was implicit in vacancy. So now meet the new rent, same as the old rent, pretty much. So that went away. But before that, we had all these apartments that were deregulated, some of them wrongfully during that time. So I have a two-part question. One is, isn't it ironic and crazy that a lot of those deregulated apartments now are going into good cause? And the other question is, isn't it in a way also bad because the legislature has now put a target on all these tenants' heads because now their vacancies have value? Because the way I read the statute, and you guys can correct me, is the old tenant's rent has nothing to do with the new tenants that comes in after a vacancy. There's no connection between what the outgoing tenant was paying and the incoming tenant is paying. Thus, vacancy has value. Thus, if landlords think, hey, that tenant's under market and I'm stuck with good cause, they're going to be pressuring that person in whatever kind of way, which is what we were trying to get away from in 2019.
Well, you're actually right. I mean, it all depends. You're right. If it's depending on the value under market, but I guess at that point you're going to look to the expenses for the building. So if the expenses of the building, I mean, insurance for buildings is absolutely astronomical.
Yeah, landlords can be over leveraged, but there's a lot of pressure to borrow more than you can run a building on. And when I see landlords saying that they're strapped, the first thing I want to know is whether they're strapped because they were expecting to speculate on their buildings. But I don't think that just cause necessarily is the same as vacancy decontrol. Uh, that's one of the big unsettled issues, right? If you look at how the rent increases that are reasonable are calculated, and yes, it's just a presumption, but that presumptive rent increase is allowed to be charged once per year, right? The
Mm-hmm.
statute says on an annual basis. So
Why? Because you be, but it says renewal leases. So you think that it's going to apply? You think it applies to vacancy? But where in the statute would you
Yeah,
point
I
to the
wouldn't make
language?
that one. I mean, I can
the
see
word
Seth making it,
annual
but
in
I
the
wouldn't go there.
calculation of the increase.
Yeah, but it talks about renewal leases. So I don't understand where you'd be making that argument. Even Michelle, who represents Senate, just said, that's not.
Because
I
it
don't think
talks
that's a
about
viable
renewal
argument.
leases, so I took it to mean that I
Yeah,
didn't, also because it didn't address vacancy in any way, shape, or form, I took it to mean that this was intra tenant, like
yeah.
within one tenancy. So there's no connection from one tenancy to the next. And
It
thus, that
it
is where it creates perhaps pressure.
yeah. This statute only talks about renewal leases and intra-tenant. It doesn't transcend to vacancy. And I understand why you might want to
Well,
try, but
but the reasonableness language.
I just think anything that creates a whole new scheme where vacancy is all of a sudden attractive to a landlord is bad for tenants.
uh huh.
And that's which probably brings us to another question I have. I see other people in our field who know more about lobbying and government affairs, people who are always, up in Albany. The chatter among them seems to be, okay, good cause didn't come out so great for tenants, but it's a foot in the door that tenant advocates can expand over time. So I think everything we're talking about would be holes that would need to be plugged depending on what the courts do. What do you say about that?
I agree that tenant advocates would want to are going to try to use this as a way to just and strengthen rights for tenants. I think as it's written now, it's much fairer to landlords and tenants because though tenants have a way to keep their rents low, but landlords still can increase the rent if it's need to based upon each building. So it's an individualized statute.
Yeah, it makes it fair to have a judge individualize the calculation of the rent. I agree with that. Uh, One thing from the point of view of tenants that this very effectively does is give people space to organize buildings. If you're protected by just cause in Albany, right, then you're not afraid to join a tenants association. You're not afraid to be a loudmouth with the landlord. You're not afraid to make complaints.
Oh, that's interesting. Cause.
There was a time when New York City was culturally more uh, organized and labor oriented and civil rights oriented. Uh, Early in my career, every building had a tenants association. Most tenants associations were organized where there'd be a floor captain on every floor, where they had regular meetings, where they regularly paid dues, where everybody knew everybody else who went to housing court. The whole building would show up very often. The organizing broke down with deregulation, and even earlier with the large waves of cooperative conversions. Just cause may bring that back, but it takes a long time to develop a culture. I have my own biases, no doubt. Look, I've seen in some of the spaces that I'm part of, like particularly in loft buildings, artists are as easy to organize as cats, right? So very often tenants associations will split up and then recombine and then split up again in a loft building, and you often do find that very individualistic, almost aggressively individualistic attitude among some of the tenants, and but in a larger culture, right? It's educational to even know that there's a tenants association, because then you know that there are rights and you know that there are people you can turn to.
I just had a woman call me whose apartment was burned out because there was a drug dealer underneath her cooking drugs, and her apartment got burned. She was woken up by a fireman tearing the door off, dragging her out. Point is, pretty much everything that she needed, that she was calling me to do, was something that could and should have been dealt with by that building's tenant association. Somebody should have been in touch with the council person. Somebody should have been in touch with DOB. Somebody should have been in touch with the fire department. Somebody should have been in touch with the police. She was just adrift. She was just a person with nowhere to go. But this puts me full circle around to the fact people still don't understand rent stabilization in this town. So now they got to understand rent stabilization and good cause.
It's going to be a problem. If I could digress to back to Seth's point about it being for free market vacancy leases.
So you have a vacant apartment. Let's just follow this up. You have a vacant apartment, and the tenant rents under a vacancy lease with an increase that was double what the previous tenant paid.
Okay.
And your claim, let's say your claim is completely valid. The tenant doesn't have a leg to stand on. It's take it or leave it. You take that vacancy lease, or you live somewhere else. So he signs it, and then it comes up for renewal. And the tenant doesn't want to renew, not because the current increase is more than 8.8% or whatever, but because the increase, when you calculate it under 216(1) I, is more than the reasonable percentage per year measured annually, which is the measurement in the statute.
Seth, it goes back to your original argument. Once you sign the lease, you've given up you have a contract. So you already said you can't do that. Once you sign the lease, somebody that was in there at a renewal can't challenge it. So now you're going to now you're backtracking, saying somebody on a vacant lease has the right to challenge it.
Oh,
that doesn't make sense.
No, but what about their second lease? Why would they,
on
why
the second lease, they're entitled to challenge the increase for that rent.
Where does it say that?
It doesn't say what you say it says. It says
all I said it says is a direct quote from the statute.
Right, but it says they're challenging the increase, but they're challenging the increase, and then the statute goes on to say the increase is a rebuttable presumption. It doesn't say the base rent is a rebuttable presumption. It's the increase that's the rebuttable presumption.
It says whether
base rent.
The question is whether the rent due and owing is the result of an unreasonable increase.
And it's a rebuttable presumption that the increase, that percentage, and then you go to you got to read, I'm
going to give him something here. Seth, what you can say too is, then why do we have to give this on a vacancy? Why do we have to give the notice on a vacancy?
Yeah.
No, you give it on a vacancy to tell the client, the tenant. The only thing you have to give on a vacancy is you have to tell them they're subject to good cause. That's it. They are subject to good cause. It goes on every lease so that they know that their rights if you get a renewal. And of course you give it on a vacancy, any notice.
Oh, and that's another difference with DHCR that's going to be more tricky for tenants. Rent stabilization has an entire registration and paperwork component imposed on landlords and to a certain extent on tenants. There's records that are reports that need to be given to DHCR that are kept, that become public records for tenants to look at.
That's why it's not subject to a vacancy lease, because nobody's supposed to look at it. There you go.
I thought you would be more troubled by that, Seth, because I really feel like the whole cat and mouse game with trying to get tenants out because you think you can get more when you get them out, that was at the core of so much consternation for everybody for 20 years. And I just feel like we've come back to that now.
Well, you could, right? I mean, if somebody's protected by good cause and their landlord would really like a higher rent than the local rent standard, which is, I guess, the phrase in the statute, there may come a time when that gap between the market rent and the local rent standard
And
is
you
so
know,
great that the landlord resents the tenant.
the
You're right.
landlord, Randy, is in the same position as the tenant, because if the landlord's going to make the case, I should get more than what I'm allowed this year on the percentage
Not
over the
allowed. It's a
CPI.
rebuttable presumption. It's just a presumption. It's not allowed. There's no.
Okay, if the landlord wants to rebut the presumption, again, there it's the same as we used to have with the IAIs and in rent stabilization, where you do it and you don't know if you've done it right until it's tested by a court later on. I mean, don't you guys agree with me that the courts are already so backed up and overburdened? And did you see they just added a whole bunch of family court judges? How come they're not adding housing court judges?
Yeah, I don't know. But yeah, I agree with you. They're very backed up, and
Yeah.
DHCR is very backed up, and the appellate
Right.
divisions are backed up. I mean, I have a case in the second department that's going on 2 years before we even get any argument. But, so yeah, things should be a lot simpler. But the thing is that when you want to balance landlords' rights with tenants' rights, it's very hard to make something simple.
In a city with 9 million people. I have one other question. Is there a penalty for not sending the notices, since you're in notice sending hell right now, Randy?
No, I don't see one.
Uh,
Seth, do you see one?
There must be.
Well, I was sort of alluding to this before when we were talking about whether the
But there
tenant
isn't.
has any affirmative rights, and whether a tenant who's signed one of these excessive leases can sort of take it back, unless one of those two things goes the tenant's way, unless the courts recognize a declaratory judgment right, or unless the lack of giving the notice can invalidate a
You mean a
tenant's
declaratory
consent to a
judgment in
lease.
housing?
Oh, go to
You know, I
Supreme.
can't thank you guys enough. I think this was good. Do you guys think this was good?
This was very enjoyable. I would come
Yeah,
again.
I enjoy it, guys. I do enjoy it. I think it'd be great to meet in person in a bar or something to do this.
Yeah,
But
Yeah,
yeah.
that's right. We need the cocktails.
Absolutely.
okay. Thanks, Michelle. I really
Thanks,
appreciate it.
Michelle. Yeah.
Take
Thanks,
care.
guys.